Attention on this channel. We've got an important message. All observations and opinions shared here are for educational purposes only. This content is intended for adults. Viewer discretion is advised. Be advised that any individuals mentioned are not intended to suggest involvement in any crime.
Case by case, got the fire.
Ha!
Yo, you wanna talk about true crime? We start with a guide that flows. Digital footprints meet criminal defense, that's how the story goes. This channel's all about online evidence, the stuff they overlook. From live stream chats to deleted posts, it's all in the true crime book. My goal is to provide insight for the attorney in the darkest hour, to find the proof that can make a case or break a criminal's power. So whether you're a lawyer or a PI, we're diving deep in the mess, exposing misconduct and hidden truths to get to the very best leads. We break it down case by case, on the trail of the facts. We show how digital evidence changes case outcomes, we on their tracks. No rumors, no gossip, just the evidence clear and concise, shining a light on the shadows at any cost or price. What do we do?
Case by case.
What's the motto? We're here for the victims, the ones who were left behind. We're here for the families, giving them peace of mind. We follow the paper trail, the digital footprints and the timelines, connecting the dots, we're reading between the lines. We don't just talk theory, we show you how it works in practice. We're here to help you stay ahead of the curve, to get a new analysis. You think you're in charge, but we're here to find what matters most. We're giving a voice to the voiceless, like a digital ghost. Digital ghost, digital ghost. We break it down case by case, on the trail of the facts. We show how digital evidence changes case outcomes, we on their tracks. No rumors, no gossip, just the evidence clear and concise, shining a light on the shadows at any cost or price. What do we do?
Case by case.
What's the motto? From digital clues. The mystery, you wanna know the answers? We're dedicated to the chase, from the first look at the scene to the final resting place. We're here to find the answers, to give the victims their due. A true crime channel with a heart and a purpose too. We're here to build up, to expose the truth, and to shine a light on the darkest of deeds with all our might. We're here for the truth, we're here for the facts, and that's it. We don't chase the trends, we just chase the truth and never quit. We let the past speak for itself, we let the facts lay the ground. We're just here to be a voice, a tribute that is sound. Yeah, it's all for the truth. All for the truth.
Ha! Come on, come on. Let's go.
Their thoughts for you, yeah. Won't kiss the room. Yeah. Ha. Come on. Let's go.
Oh. Trying to get my whole screen in here. Hi, everybody. Welcome to Case by Case. Happy, what is today? Sunday. Happy Sunday, y'all. Today we are joined with some very serious special guests, and we are going to be talking about Ashley Garth case status and where her case right now is standing with the courts. We're also going to be talking about some of the Delphi connections, Nick McClellan being one key factor in both cases. And hopefully we're going to have some legal bombs dropped today, because I have with me, everyone who's with me today is all lawyers. I'm the only non-lawyer. So I'm going to introduce them one by one. If you haven't hit the like and subscribe button, please do. I know a lot of people are complaining that they're not getting notifications. That's YouTube, that's not me. So make sure that you're subscribed to the channel and that you have your notification bell on, I guess it has to be set on all for notifications. Here recently, I feel like I'm getting tons of people saying, I didn't get a notification. So I apologize. But so we have this live at 1 o'clock. And then again, we have another live at 5:30 where I'll be joined again with Meringue, where we're going to be going over the transparency and the Patrick Westphal messages and insight. So you can watch this and then hop back on later and follow up with the second live today. So we have a lot going on. So let me introduce, you guys all know Cherie. Cherie is an attorney from Syracuse, New York. She's worked with me on the Ashley Garth case almost pretty much from the beginning. And Cherie and I just traveled to Delphi this past October for the second time and visited with Ashley. Say hi, Cherie.
Hello, everybody.
And then next we have Terry. Terry is a new contributor to the channel. Not new, but she's a new face. She's an attorney from Georgia. She also is the owner of Trinity Reflections. She's the website builder for the Case by Case website, and she does a lot of other things, but she's also very interested in learning about Ashley's case and has a lot of legal expertise and behind the scenes work that she's done in numerous other cases and different states. So welcome, Terry.
Hi, everybody. I'm a little bit under the weather today, but I do have to shout out to Michael and say, go dogs.
Next up, we have Michael Osbrook, who is, you guys all know who Michael is. He's a fabulous attorney from Indiana, specializes in habeas corpus. And he's here to basically guide us down the long road that we've been on with this case and give us some better legal insight into where things stand with Ashley's case, the recent filings, and what it all means. And at any time now, we're also going to have Travis Williams popping in, who is another attorney who has worked with Cherie and I on Ashley's case almost since the onset. He's an attorney from Texas. You guys probably know him best from Case by Case, and he's spent a lot of time being featured on Criminality's channel. So I believe right now he's reviewing some filings, and then he will be on momentarily. But for now, it's us four, and welcome. So basically what we're doing today is, it's been a long time since we've discussed Ashley's case on a live. And I know that a lot of you have messaged me wanting to know what's going on, why I haven't discussed it, or I haven't presented anything publicly. And there's a lot of reasons why. One is for the protection of Ashley's case, making sure that we're not putting too much information out there, because we are now in a very critical transition in her case. And I've always said that, you know, the wheels of justice grind hard and slow. And we've gone through many phases with Ashley's case, starting from her direct appeal to the 2-year waiting period just to be assigned a post-conviction relief attorney, to going through all of the post-conviction relief filings. Then we did have an evidentiary hearing, which Cherie and I attended. And a lot of good information was presented at the evidentiary hearing. And we were left with waiting, you know, for all of the filings to take place, the state's response, which ultimately led us to, you know, and before I go on, there's a whole plethora of information regarding the post-conviction relief filing. And even though her post-conviction relief was denied, the seesaw tilted still in Ashley's favor. When you're talking having to meet 9 prongs, Ashley's case met 8 of the 9 prongs. So we are stuck with her case being on the turning point of only one, of being the issue to get us over the hurdle, to get her conviction overturned or her case remanded or possibly a new trial. So before I go into any of that, attorneys, is there anything that you guys want to add?
Well, I think the only thing I'd add is that, for the people listening, is that the 9 prongs are related to newly discovered evidence.
Mm-hmm.
And the question, so the Court of Appeals said that Garrett Kurtz's murder conviction was merely impeaching. And that's kind of what the argument, that's what the newly discovered evidence argument's about.
So for those of you who are new to the case or who don't remember the facts, basically what had happened was Garrett Kurtz murdered Ray Hainish, according to the coroner, on March 13th of 2019. Garrett Kurtz was pulled over in Ray Hainish's car, accompanied by Nicole Bowen, on the 14th. Garrett did not have a license. There were drugs, all different sorts of things in the car that ended up causing both of them to be arrested and the car impounded. Ray's body wasn't discovered until that Saturday, which was March 17th. At that point, it was stated publicly that Ray died of natural causes. It was 16 days later that Garrett murdered Nicole. And by the time they found Ray's body back on March 17th, and they were able to put 2 and 2 together, okay, we have these people in a dead man's car that's in the impound lot. They went looking for Garrett and Nicole. Well, prior to law enforcement being able to speak to either of them, Garrett got rid of Nicole. So for 6 months, it was stated that Ray Hainish died of natural causes. And then 6 months later, the truth came out about Ray Hainish's death and how he was found. He was found tied up. He died of ligature strangulation. His apartment was completely trashed. His family is on record on another podcast discussing what the status of the apartment was in when they were allowed in after the crime scene was released to them to go in and get Ray Hainish's items. And it was in complete disarray. So as of 2021, this was 2019 when Ray was murdered. Ashley's trial took place in May of 2021. No charges had ever been filed against any suspect in the Ray Hainish murder. It wasn't until after Ashley's case went to the jury and she was convicted. It was after that the charges were filed against Garrett. So therefore, anything regarding a motive for Garrett to kill Nicole, none of that was allowed into Ashley's trial. None of it was allowed to be discussed. There was a letter written by Garrett to Ashley explaining the circumstances of that murder, also explaining to her why he killed Nicole, and also trying to coerce her to keep her mouth shut. And that letter, because it included information about the Ray Hainish murder, was not permitted to fully be allowed in the trial. Then the judge only allowed a certain excerpt of that letter to be read in court. The letter was given to the clerk, and when Ashley was found guilty, the same attorney her public defender was allowed to file her direct appeal. Well, upon filing the direct appeal, she made note of Garth's letter in the direct appeal, but the actual letter that Garth wrote was not physically transmitted to the direct appeal court. So she failed to follow through and make sure the court actually had access to read the letter. And that became a huge contention during the post-conviction relief hearing, the evidentiary hearing, when Ashley's original attorney was brought in to testify about why she didn't follow through. And it was basically a he said, she said. Ashley's public defender claimed, well, I gave it to the clerk. I thought she was going to file it. The clerk was like, no, it's not my responsibility to file it. Therefore, on the direct appeal, the court didn't get to see the letter in the entirety, which ultimately was detriment to Ashley, because the letter is factually a confession that Garth killed Nicole for his own reasons. And then he also, in the letter, threatened Ashley that she needed to keep her mouth shut. So that's that's the main thing about the letter. And the merely impeaching, meaning, is it merely impeaching that Garth's character or his testimony can't be trusted, or is it more than that? That's the argument at hand in the ninth prong that the appellate court is claiming Ashley didn't meet. And that's basically the argument that we're left with. Everything else, the Court of Appeals agrees. The other 8 new evidence, the new evidence that was filed in this case all meets the standards. The state and the appellate court is disagreeing with the merely impeaching aspect of this case when it comes to the letter. So Osbrook or Terry or Cherie, somebody.
Hey, Amy, I think it would be good for the people watching to understand the difference between merely impeaching, because that's one of those little bitty, tedious things that everybody may not be thinking about.
Yeah, it's for me, the merely impeaching, it's a fine line between impeaching, witness credibility. And the way that John Pinto wrote it in his briefs is it matters because, well, first of all, backing up, and another element to this case that wasn't raised during the trial was that you have the prosecutor, Jeff Dorinsky, questioning Garth Kurtz on the stand and allowing Garth Kurtz to claim that I'm here to do the right thing. I wasn't promised anything. In fact, because I'm here testifying, my life could be in danger. I have nothing to gain from this. Well, Ashley's public defender never put forth to the jury, wait a minute, because upon the initial arrest of Garth Kurtz and the circumstances surrounding Nicole Bowen's murder, which all the headlines read, she was strangled and she was tortured, and he was going to be seeking life without parole. Well, life without parole is what he stated publicly in a news conference. It's stated in the newspaper. I have the article. Then he turns around, and now Garth is not only being charged and sentenced to the normal standard, he's being sentenced to less, which was 55 years with the 80-20 of time served and him having the possibility of parole. So Garth did actually benefit whatever behind the scenes deal they made when Jeff Dorinsky was initially claiming he was going to be seeking life without parole for the murder and torture of Nicole Bowen, they wanted us to believe that his testimony didn't gain him any ground, but yet we see that it did. But that was never raised in court either. But the merely impeaching goes to the credibility of the witness. And John Pinno's stance is, if the jury would have known that the individual who's sitting here, number one, he's telling you he has nothing to gain. That was a lie. The jury was never told that 14 days prior to this murder, he had actually killed, by the same means, a man. And they never even heard the full story from 8 weeks before that, on January 21st, where he broke into, laid in wait, and hid in Ashley's home for her to come home from work, where he attacked her, hog-tied her with duct tape, stuffed a sock in her mouth, taped her mouth shut with duct tape, beat on her, and strangled her unconscious for over 2 hours, which is all in a police report that we have that was never presented at her trial. And when he was confronted with it by Ashley's public defender at trial, he simply said, "I'm not discussing that. Those charges were dropped." Well, yeah, he's right. Those charges were dropped without a hearing, without anybody being confronted in a courtroom. He was arrested that day. Then there was a restraining order filed. Then he violated that restraining order twice. And each time he violated the restraining order, he was let out the same day. And after the second time of him violating that restraining order, 14 days after that, he killed Ray Hainish. And then 16 days after that, he killed Nicole Bowen. So for anybody who thinks that this man isn't capable of lying and sending someone who he believes betrayed him, such as an ex-girlfriend like Ashley Garth, for telling on him, to prison for the rest of her life, he was willing to take a life to keep someone's mouth shut. So the jury heard none of that. So it's absolutely, John Pinno had it right. It's absolutely more than merely impeaching. Okay, off my soapbox. Go ahead, guys.
So, I kind of see it as a collision of, yes, it's more than impeaching, but it's kind of a collision. So to explain maybe to the audience what evidence that's merely impeaching is, let's go to Delphi.
Yeah.
People might recall that Andy Baldwin tried to impeach Weber about the time he arrived home with a prior statement he gave to the FBI. Now, Gull didn't allow it, but if she had, it's not understandable really why she didn't allow it, because he did it in the classic way that you do impeachment. But his prior statement to the FBI was that he got home at 3 to 3:30, something like that. That he'd been out, not that he'd gotten home about 2:30, and that was important. But Weber's prior statement to the FBI was, because it was offered as a prior statement to impeach him, the jury would have been instructed that isn't actually substantive evidence that he got home at 3:30. It's just evidence that you shouldn't believe him necessarily. Up to the jury to decide which statement is true or which is not, or whether to believe the 2:30 statement. It's not actually what's called substantive evidence that he got home at 3:30. So the place that the murder of Hanish gets into this is under
Well,
evidence rule 609.
Well, apparently, hold on one second. Apparently, I misspoke, and I forgot about. Hold on. Apparently, we do have the Ray Hanish autopsy, and Cherie just sent it to me. One second. So that would be Garth Exhibit 4. Okay, so here is, I'm uploading it now. We do have the Hanish autopsy, and they have it, mauled over with watermarks that says Ray Hanish, 202 North Boone Street. He's a white male, who his parents are. He was cremated at Geisen Cremation Center, and his cause of death here is asphyxia due to ligature strangulation.
I sent the wrong one. That's the death certificate. It's Exhibit 5, so I'll have to send it to the right one now. Sorry.
Okay, that's fine. That's fine. But yeah, he definitely, it was the same cause of death as the attempted murder on Ashley in January, and then the subsequent 2 murders of Ray and Nicole. They're all 3 exactly alike, hogtied. I think that I truly believe that when he attempted to kill Ashley and strangle her, he did it multiple times. It was his first time, and he just simply didn't know how to complete the job. Luckily for her. But he was trying to do it with his bare hands, which he attempted to do with his bare hands with Nicole, which he succeeded in incapacitating her based on based on the bruising and the black and blue marks on his arm. 5 days after the murder, I mean, they were still prevalent. There's photographs of them, but I do believe that he's a serial killer for sure. So I'm sorry, Osbert, go ahead. Michael?
Sorry, I was muted. It kind of runs into a collision between evidence rule 609B, 609A, and then 404B. So 609A is about crimes that you can use to impeach somebody, which is just attacking their credibility, and says for the purpose of attacking the credibility of a witness, evidence that the witness has been convicted of a crime or an attempt of a crime must be admitted, but only if the crime committed or attempted is murder, treason, rape, robbery, kidnapping, burglary, arson, or criminal confinement, or a crime involving dishonesty or false statement, including perjury. So murder is specifically listed as something you can just, so to impeach somebody's credibility, all you have to do is say, well, they've been convicted of murder, and so you shouldn't believe them. Then there's 404B, which is labeled crimes, wrongs, or other acts. And, B1 says evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion, the person acted in accordance with the character. So, you can't just put, you can't put the burglary conviction from 5 years ago in well, you can put the burglary in because it's listed as to impeach, but you can't use the burglary conviction just to show that somebody's a bad person, right? And so they did this. But B2 says that this evidence may be admissible for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. So you can get, the typical thing is you can get evidence of another crime, other act, and to show modus operandi, MO.
Right.
And you've got ligature strangulation, and so you could technically, I think, get as substantive evidence, right?
Mm-hmm.
Not as merely impeaching evidence, get the ligature strangulation in as proof of identity. And motive. So yeah, so the Kurtz did, Kurtz was the one who murdered Nicole Bowen. Anyway, they kind of run it, the substantive evidence versus impeachment evidence, they kind of run into each other because it's murder.
And what weight does that carry? Because it didn't seem to carry a lot of weight with the appellate court. That was the ninth prong. That was the one prong that they claimed she didn't meet. And they were provided the letter, which the letter was definitely a confession to, this is why I killed her, and I need you to keep your mouth shut. And they ruled on the side of that was just merely impeaching. So based on the filings for the transfer to the Supreme Court, what is the argument that has been put forth strong enough to get her over that ninth prong hurdle?
Yeah, I mean, it's going to be up to the Indiana Supreme Court, right? And I don't know. I mean, the Indiana Supreme Court, one of the interesting things for the Indiana Supreme Court to take this case about is that, on the one hand, so the findings of the trial court really the factual findings contradict its conclusion, and kind of goes after that. So that's the question of law, what you do when the factual findings kind of contradict the legal conclusions. That would be a reason for the Indiana Supreme Court maybe to take it. Yeah, I don't know. But I will say that the newly discovered evidence question is not going to get any traction in federal court. So this is really the last chance gas on the newly discovered evidence part of this.
So when it comes to the category of newly discovered evidence in a case of any type, when, for example, a public defender or an attorney doesn't have any knowledge of certain interactions or certain behaviors that a state's witness was involved in, and then after the court rules, the jury, implements a verdict. What type of new evidence constitutes a complete reversal of charges or a sentence?
Well, I mean, one easy thing would be, so I say it's easy, it's really not newly discovered evidence, but for instance, Christine Bunch's arson case, she was convicted of murder for setting her, I think it was a trailer, on fire and killing her child. And arson science changed, and that was treated as newly discovered evidence. But if you want, and that's a little weird, right? It's not really newly discovered evidence. It's casting existing evidence in an entirely new light. And maybe it should have been called something else. I don't know. I mean, if you discovered, I mean, somebody confesses and you get the confession. So newly discovered evidence. Here's one, Julie Ray's case over in Illinois. Now it didn't come up as newly discovered evidence, but it ended up being part of her retrial, and that is a serial. So Julie Ray was convicted of killing her son Joel in Illinois, and after a bit of time, a serial killer in Texas confessed. And I mean, the other thing is newly discovered evidence is witnesses can recant.
So when you look at the letter that Pinot presented during her post-conviction relief filings, the whole letter in its entirety that wasn't allowed at her trial, that he's confessing, like, this is the reason why I killed Nicole. And then he goes on to discuss, yes, there was somebody else who was killed. I'm not going to go into details about that, but don't believe everything that you hear. I mean, so Ashley was charged with conspiracy to commit murder. And apparently her co-conspirator would have been Garrett. But yet on all fronts, it was supposed to be Garrett, Jason Palladino, and Ashley, which Jason Palladino was never spoken to. He refused to speak. It's one of those Patrick Westphal things where, I'm not going to speak to you. So everybody says, okay, and bows out gracefully. And he's let completely off the hook. But then you have Garrett supposedly conspiring with Ashley. On what foundation does it make any kind of sense that someone that she's conspiring with to kill someone, that individual is providing her an explanation as to why he did what he did? If she was a co-conspirator, wouldn't she already know? Wouldn't it have already been a pre-planned scenario that they acted out together? But yet we have this letter where he's confessing to, this is why I did what I did. I need you to understand this. And then also on top of that, we have another murder that I'm being accused of, which I did commit, but I'm not going to give you any details on that. And in the meantime, you need to keep your effing mouth shut.
So here's what the letter might be extremely useful for the conspiracy charge. So to prove a conspiracy, the state has to prove that there was an agreement to commit a crime, and that one of the parties, only one of the parties to the agreement, committed some overt act, the language goes, in furtherance of the agreement.
Mm-hmm.
So what the letter would go to show, I think, is that there was no agreement between Ashley and Kurt.
No, there wasn't. And
well, but I think that's what I think the letter may show that, and I've really not had their evidence rules about the admissibility of statements by co-conspirators. I'm not. Travis might be up on that if he gets here.
yeah, he's in the chat. I'm texting him now.
Tell him to get his sorry self in here, because he knows a bunch more than I do.
Yeah. No, he's been on this case from the very beginning, and this is a very it's a complicated case from the outset until you understand it. Well, it's just like Delphi. All of the inner, you know when you've reached a dead end, and you know when people are saying things that just really don't add up. But there are so many facets of this case that, first of all, from the very beginning, Nick McClelland really put the hook, line, and sinker on Ashley when he failed for almost a year and a half to bring Garrett in front of a judge for his breaking and entering and his attack on Ashley. If you go to Garrett's My Case status and you look at the case, it was postponed after being postponed after being postponed. And Garrett never, other than the first initial hearing, Garrett never was brought back in. And it almost seemed like the charges in Newton County for the murder of Nicole was the specific reason for the charges being dropped. Like, okay, well, these charges don't matter anymore. We're going to let Garrett off the hook. We're just going to drop the charges, which in fact is what really hindered Ashley from using that defense in the position that she was put in. And no one wanted to hear it out. The judge didn't want to hear it because the charges were dropped. There he is. Hi, Travis.
Hey, y'all. Can you hear me?
Mm-hmm.
Go ahead. I've just been listening. You've got the team in here. I don't think I really have anything more to add, but I had some questions for Michael. But go ahead and finish your thought.
No, I was just saying that Nick McClelland dropping the charges against Garrett and not enforcing the no contact orders 2 in a row and letting him out, which then led him to proceed to kill 2 people. These were issues that were never brought to the forefront. And unfortunately, Ashley really, and I'm not trying to downplay the role of a public defender. What I'm saying is that Ashley trusted her public defender. Her public defender was telling her a lot of things that made her believe that she was doing her due diligence, and her due diligence wasn't being done. I mean, the week before the trial, Ashley was sent home with her case discovery in a box and was told to look it over. There was never a sit down between Ashley and her public defender to discuss the case. And then everything that came out in the trial was like shocking to Ashley. And she's writing on the legal pad, please help me. What is happening? Like, what, that's a lie. And the attorney didn't know how to respond. So with Garth's letter, which I think that her attorney did home in on, it just didn't come enough. It just didn't come across strong enough to be more than merely impeaching. It was actually a confession. And then on direct appeal, the whole entire letter never made its way to the appellate court, which was that started the foundation for the post-conviction relief. But I mean, I have a whole plethora of a list of things that were left out of the PCR that I feel would not only would have made a difference, but if they would have been presented at trial, would have changed the outcome. And I just don't know how you guys feel about that, but I do have a list that I can pull up.
So the appellate opinion, the Court of Appeals opinion, which I've not read, I read all the transfer documents, so I could glean from that the state's opposition to transfers based. It was not new evidence. It was merely impeaching, and Michael's already addressed that. But did they
I get it
also
right?
yeah? Did they also discuss it? Did they also bring materiality that even if this was new evidence, it wouldn't be material because of the DNA evidence, or they didn't mention anything about that? That's always what I thought was going to be the toughest hurdle. And
Well,
did they mention that in the opinion?
it was not, okay, so it was not, that I remember it was not mentioned in the opinion. It was raised, it was raised by the new prosecutor at the evidentiary hearing, that she stated in open court that Ashley's DNA was on the extension cord, which it was not. And it's been repeated in filings by the state that based on Garth's claim that Ashley pulled on the cord so hard that it broke. Well, number one, Ashley's DNA is not on the extension cord. That testing was inconclusive. Number two, I have the exhibits pulled up right here, and I'm going to pull it up. I'm going to show you. And this is where I think Garth got that idea, because Garth is a mastermind of lies. But in the autopsy report, when Nicole's body was brought in and they were going over all of the items on her person, here it states that there was an extension cord wrapped around her neck that appeared to be cut, not stretched and broke, but was cut. And it's at the very top of the page. Documentation is taken before and after removal of the ligatures. There is a brown extension cord that is cut on one end and is wrapped tightly in a knot present around the descendant's neck. So the extension cord that Garth is talking about during the trial, that he claims, Ashley, first of all, if you go back to Garth's interrogation video, Garth describes to Detective Rowe where he got the extension cord. he explains in detail that he went behind the TV and the extension cord was plugged in to the wall and the surround sound system, and that he tied it around Nicole's neck. And then Detective Rowe says, I thought you said Ashley tied it. And he goes, oh, no, I meant to say, no, Ashley handed it to me. And then I tied it. That's a lie. That's a full-blown lie. Just like it was a lie that for 3 hours he sat in an interrogation video with Detective Rowe, telling Detective Rowe that Chris Mathis murdered Nicole. But we now know, based on the autopsy report, that the extension cord around Nicole's neck wasn't stretched, pulled, and snapped. I mean, think about that. What strength would a female need to have to tie an extension cord around someone's neck and pull it so hard that it snaps? That's not going to appear in an autopsy as being an extension cord that had an end cut. That was a lie among all the other lies.
And I think Michael will tell you whether they're lies or whatever in the appellate post-conviction context. They're questions of fact for the jury. And there's just not much you can do with that. Typically, I think Michael will tell you, it's just water under the bridge at this point. But so the DNA they classified as 3 levels, and the Garth'S was for sure on the cord, and then only Ashley's was on the scarf, or was it on the duct tape?
No, Ashley, yes, Ashley's was on the scarf, but it was at like 18 points out of trillions. Like, so it was more than likely transfer DNA from Garth'S, because Garth'S chased her back into the bedroom and hit her. And according to all accounts, she was hysterical and crying. He hit her in the face. Then he went back out and he tied the scarf. Now, the duct tape, Ashley's DNA was not on the duct tape. It was on the inside of the cardboard roll, which, when that was brought to her attention that your DNA was on the cardboard roll, she said, well, I used a roll of tape earlier that day because the phone that Garth'S left at the trailer, the battery kept falling out. And I took a roll of tape and I used that tape to tape in the battery on the back of the phone, which that phone with the tape on it was admitted into evidence at the trial. Those were the only 2 places.
Yes, this, kind of all boils down, this is why those attorneys that practice in criminal appellate work and post-conviction, that's actually a board specialty in Texas. You can get board certified in certain areas, and one is criminal law, but then there's a completely separate board specialization for criminal appellate and post-conviction work, and that's why all those attorneys are like Michael. They're, super brilliant, because you have to figure out ways to hook in something that looks like it's impeachment, walks like it's impeachment, smells like it's impeachment, but you are able to fashion it as new evidence that justifies a new trial. And there's a brilliance to that, cannot be underestimated. And I've seen it over and over and over again, because all of these things that are factual issues, and that when you put all of those facts together and you have a good understanding about it, it just doesn't make sense. That doesn't fit with the prosecutor's narrative. But I don't know what the standard is in Indiana, but you just need to undermine confidence in the verdict. And I think
Actually,
the things. Go ahead.
with newly discovered evidence, you've got to do more than that. It's not Strickland or Brady. It's actually more likely than not it will produce a different result at trial,
Right.
at a retrial.
Which is why, people like you, Professor, fashion this stuff under different pigeonholes. It's Brady, it's IAC, and it's new evidence. And, there's a knack for that. And I forgot that it's such a tough standard on the materiality prong under, Brady and IAC that. Say that one more time, what it is.
So for Brady and ineffective assistance, you only have to show that the suppressed evidence or the thing the lawyer screwed up, if done correctly, there's a reasonable probability that the suppressed evidence or the lawyer's mistake corrected would produce a different result at trial.
A reasonable
slightly higher thing.
So, I mean, but is the bar that minimal that you only have to show a reasonable amount? Because I feel like it's an astronomical amount.
Michael needs to explain what the cases say reasonable probability means.
Yes.
I think.
Yeah. So for a long time, there was a great capital case that Judge Posner wrote saying that a reasonable probability is a non-negligible chance. And that was always fun to quote, but Harrington v. Richter came along from the U.S. Supreme Court and said it's less than a preponderance of the evidence. A reasonable probability is less than a preponderance, but not much less. But it's a preponderance of the evidence in Indiana for newly discovered evidence. So it's more than, look, these are all hypothetical things for appellate, right? I mean, in my habeas class, we'd spend 2 days on prejudice standards, and
Yeah.
So Scalia wrote a great. So I think it was a Hispanic name, something Benitez versus United States, where he wrote a concurrence saying, this is all this. Yeah, he identified, I think, 4 different prejudice standards, and said, this really doesn't have a lot to do. This is like conjuring.
Yeah.
There are, in fact, something like 8 different prejudice standards, depending on how you count them up. There might be more than that. But I just scanned through the Court of Appeals opinion, and they just hung their hat on impeachment. They didn't say anything about the probability of a different result at trial, which is terrible, right? Because somebody's critical testimony, if impeached, that witness might be important enough so that if their testimony is impeached, I mean, that likely would produce a different result at trial, but we're still going to affirm those convictions.
Yeah.
I mean, the standards are what they are. I mean, I can't argue with them, but there's.
So if
Whether
it's,
the standards are a good idea and how they're applied is an entirely different question. But no, as I was saying earlier, this whole newly discovered evidence thing on Kurt, um, it's not going to get you anything in fed court because it's not a federal claim.
I mean,
Right.
but so how do you present at the or argue that at the original trial, if the full blown background of all of the things that led up to this event, where Garrett and Nicole were living at the Palladino property, and there was all of this physical abuse prior to, from Kurt's onto Ashley. And if he would have been confronted with that on the stand, and then it would have been brought to light on the stand, for example, so you and Nicole were living at the Palladino property for all this time. When was it exactly that you would have brought Ashley into the fold to conspire to kill Nicole, if this was the place where you and the new girlfriend were living? That was never presented. But I mean, I'm saying in front of a jury, that would have, maybe perked up some ears. And then you've got this whole situation where they're pulled over in Ray's car, and we haven't even talked about Mikey Hiddle, where Garrett and Nicole went to jail that night on the March 14th because Garrett was driving without a license, and they had a syringe, methamphetamines, and a scale in the car. And at the time, Tippecanoe County, who pulled them over, did not know that the car belonged to a dead man because his body had yet to be found. But there was a whole lot of shenanigans that went on in between their arrest and them getting out. And at that point, Garrett learned that Nicole had told Tippecanoe County Sheriff's Office that she was willing to snitch on him and where all of the drugs were coming from, which would have been the Palladinos from Arizona. And that was the reason for the Palladinos and Talitha to say, okay, she's got to go. She's going to run her mouth. And
Yeah, the problem with all of that is what you're saying, Amy, is all rational, logical thought that makes sense, but it all comes from the mouth of someone that thinks irrationally because of chronic meth abuse, Garrett. And so you can't, the way to go on this thing, I always thought, was Garrett's a lone, crazy, serial strangler. And I thought it was ineffective for Lori to not even try and talk to Palladino, because Palladino's attorney, if approached, would have no problem producing an affidavit from Palladino saying conversation never took place, there was no drug activity, this is all in Garrett's head. No one reached out to me from the defense. I would have testified to this at trial, and there was no conspiracy. This is just typical Garrett, crazy Garrett when he's on meth. It's all a figment of his imagination. And so, we have a Duty to investigate any case where an attorney appointed, retained, and it all comes from death penalty cases where not finding out if not finding out info on mitigation, that the defendant had a serious health issue when they were young, brain injury when they were young. Those are things that result in reversals because the defense attorney didn't investigate, and because the stakes are so high. We execute people in Texas, and we're very proud of it, apparently. But it's like we're in a competition every year with Florida, who's got the most. But anywho, the it just baffled me when you told me, yeah, no one reached out to Palladino. So again, this is the difference between what happens in the appellate arena and how the appellate attorneys fashion things versus what all of the facts may be. And you got to go with what you have. And primarily, you got to go with what's still preserved for appeal or what's still viable for post-conviction state. And then, unfortunately, doesn't seem like there's much left, for further appeal with federal habeas because they're not federal claims. But you have to. So all of those facts would have been nice with, an attorney to effectively cross-examine. But to Michael's point, at what point is merely impeachment, does it become ineffective? And just very, very frustrating, and why I don't do appellate or post-conviction. I'm not smart enough to do it, but to come up with things that, even the most competent lawyers would have this information, absent the court not giving them the resources to get an investigator to approach Palladino. But you got to do it the right way. You can't approach Palladino, oh, we're going to subpoena you to trial, and you make sure that Palladino understands this is what we expect. We think you're going to testify to is Garrett made all of this stuff up, and that there wasn't any drug dealing out there. There wasn't any of this. And of course, he's going to take that. And I think Palladino had some sort of more minor drug offense going on at the same time, and that his defense attorney eventually became the DA in one county, didn't he, Amy?
It just seemed to be honest, I can't remember. I don't remember. There was never any interview that was done from the onset in this case when Jason Palladino's name was plastered throughout all of the probable cause affidavits with Garrett and Ashley about being the co-conspirator or the person who ordered the death of Nicole to be done. I have no information on any interview other than being told not only by John Pinto, but also by Lori James, Ashley's original public defender, that he refused to talk. Yet he was named in the PCA, and he was also named during the trial as being a co-conspirator. But weeks leading up to this event, Ashley was never at the compound or at 6045 Hodges Drive, where Jason Palladino was residing. It was Garrett and Nicole, Talitha Beckley, and Jason. And they charged her with conspiracy without proof of any conspiracy other than Garrett Kurtz's testimony, which came a year and a half after his arrest, that he had plenty of time with the prosecutor's help to derive a story. And that story included, well, me and Jason and Ashley conspired to kill Nicole. It wasn't Ashley. It was Talitha Beckley who was living there. Ashley wasn't there. And then the white hat scenario came about, which we've completely blown that out of the water. And I mean, I'm just so frustrated on what is, I mean, I understand the law is the law, but at the same time, when you have an attorney who fails to even lift a finger to do any kind of investigation or to present any kind of a defense, there was no defense presented in Ashley's case. Although
I can totally understand your frustration, because reading through the transcripts way back when,
there was no defense.
felt the same way, and clearly, I think there was a way underestimation of how convincing Garrett could be.
And I don't even think, the thing is that Garrett was only convincing because he wasn't confronted. The initial confrontation in the courtroom with Garrett was bringing up the initial January 21st, breaking and entering, hiding in wait, attacking Ashley, duct taping her, hog tying her, and stuffing a sock in her mouth, and then strangling her unconscious multiple times for over 2 hours. That whole entire scenario never came into trial because Garrett flat out said, "I'm not discussing it." Why? Because Nick McClellan dismissed the charges. And the public defender had no pushback. She had nothing to say. That information, none of it came in. And that was that. And then he went on to violate 2 restraining orders.
Right. Yeah, we get all of that. But so I think to help better understand where this thing's at from an appellate post-conviction point of view, it's important to understand exactly what she was convicted of. And she was convicted of, correct me if I'm wrong, but at least 2 charges. One was murder, and but as a party, by handing the extension cord to Garrett. Garrett said, "Yeah, I strangled her," and then had that weird second interview, and and yeah, I was worried she was going to be brain damaged, so I finished her off, is essentially what he said. It was just like the weirdest thing I've ever seen. And so there wasn't any question that Garrett was the primary perpetrator, but she was convicted of murder for assisting.
Conspiracy to commit murder and murder.
And then she was also charged with conspiracy, right?
Yes, it was conspiracy to commit murder and murder.
Right.
Those 2 charges.
So the murder was handing an extension cord. And so the evidence about the serial strangulation Yeah, the way you'd want to present that is that it is that he is capable of committing an unaliving all by himself, didn't need help from anybody. And so the fact that he's come up with this thing that he perceives will get him the opportunity not to have an LWOP, life without parole, that if he can implicate Ashley, it'll get him to 5 below the max of 60 for what that is in Indiana. And
I think his total. I think what he should. I think the maximum would have been 60.
60 got 5 off for that, and LWOP was off the table.
Right, which was that was supposed to be what was pursued from the very beginning because
And
of
then
the
the other
torture.
dirty deed was there was some unwritten agreement, had to be, with the other county on Mr. Hamish's incident where they said, hey, you guys came back with your thing. We really don't want Lori, Ashley to know that we've now established we do have a case that we're going to pursue against Garrett for an earlier murder. And that, I thought that was a very, very strong argument that our post-conviction attorney made. I thought it was very, very compelling that they were holding that back, and that was new evidence. And yeah, it's impeaching, but then it also prevents a whole theory of defense. It denies the defense lawyer a theory moving forward. But the thing is, it's a very specific argument. The argument about the abuse and all of that, which a lot of people got confused with early, wasn't to show, well, she's under his spell, she's going to do what she is told to do. It's coercion. Really wasn't for that, at least post-conviction. It was his MO is strangulation, and he doesn't need help. And the only thing that he is saying now, contrary to what he's said at least on 2 prior occasions, is that he got some help by her handing him the cord. And so there was other problems. She should have had a DNA expert to come in and explain what
So
these.
where does the court stand, especially at the appellate level, when you're dealing with someone who's never been in a trial or accused of such a heinous crime? When you say they should have had a DNA expert come in, whose responsibility is that? Is that the defendant's to request, or is that the public defender's obligation to provide?
Let's go. Baby form underneath the pen.
Michael.
1021.
1021.
Well, so what would explain what a DNA expert would have?
Well, my problem with the DNA is, number one, we have proof that they took oral, anal, and vaginal swabs of the victim. But then when we get the autopsy report, we have no DNA profile of the victim. They said we have no DNA profiles of the victim. Almost the two areas where Ashley's DNA, which are both very small, minute amounts of DNA on the scarf and on the cardboard of the duct tape, where her trace DNA was, they also involve mixtures. So we have that, but we don't have an explanation as to why at trial we had a lab technician testify, and he did nothing more than read the analysis, not the actual PCR DNA report that gives you the actual profiles of each person's DNA and how it was obtained. He read the analysis report. Dr. Silkman said that is bogus. You can take the analysis report and you can look at it like it's an overview, and you can spin it any way that you want. We need the PCR report, which is the same thing that we are lacking in the Delphi case. We have all this DNA and this subliminal analysis of all this DNA, but we don't actually have the PCR report. They talk about it, but it's not presented. And none of that was ever challenged. And to be honest, I don't think it takes rocket science to realize that an average Joe like Ashley Garth, not ever being charged with a crime of this magnitude, would know that her defense team would need that sort of an expert. So that, where does that decision rely with? Does it rely with her?
No,
Or does it rely with
It's definitely with defense counsel. I mean, one of the
Yeah.
cases actually led to an exoneration. One of my cases was Dwayne Dunn and the failure to get a pathologist.
But Michael
Yeah.
explained that in the post-conviction process, you all got a pathologist, you all got an opinion, and so to answer your question, Michael, we don't know how it would help. We think it would help in explaining the mixtures, that it wasn't evidence of anything, and then also explaining innocent transfer. But in that case you just mentioned, you had that led to an exoneration, y'all got a pathologist. For whatever reason, and I think he had valid reasons, the post-conviction attorney at this stage felt, he didn't want to go that direction to retain a DNA expert to see if it would have made a difference. But Amy, you've got to go that step.
Let me say, let me say, John Pinot is one of the most experienced post-conviction lawyers in the state.
Yeah, I vetted him. I ran him by Michael, and I ran him by a couple other sources, and everybody. I'm not casting any aspersions on him. Everything I saw that he did was, the caliber I see with the top-notch post-conviction people, and so let me just state that. And everybody I talked to, including Michael, at the time when she was finally appointed someone to handle the case after a year and a half or 2 years of being on the list, said the same thing Michael did. But go ahead, Michael, about the...
Well, the only thing, I mean, there is something about the white hat that, I don't know, maybe it's just because of, I mean, John's done habeas cases too when he was in private practice before he went to the state PD's office, and he was really good. I mean, I would have backed up the IAC claim on the white hat with the newly discovered evidence claim on the theory just to put the Court of Appeals in a bind, because they can't say both, well, the lawyer really couldn't have known about it, and then say it's not newly discovered.
Right. So that's one example about post-conviction attorneys play chess. You know, trial attorneys like me, we just play checkers. It's a whole different level. I keep saying that, but this is exactly the type of thing a post-conviction lawyer, the type of things that they come up with that.
And here, okay, hold on one second. I'm just going to give you guys a brief explanation of why, of not just why the white hat is important, but the prosecution office put up, it was literally like a 20 by 20 on a pedestal that sat in front of the jury for the entire week of the trial, showing a photograph of Nicole Bowen. And it wasn't until the end of the trial that anyone was made aware that this photograph was going to be implicated, that this was the last photograph that Nicole took of herself based on Garrett Kurtz's testimony. This was a photograph that she took of herself on the day that she died. And that's this photo right here. Now, the problem is that this photo was displayed in the courtroom. Ashley's public defender never requested any kind of metadata. When, where, and timestamp was this photo taken? It wasn't until Garrett Kurtz was put on the stand that Garrett said, yes, she took this photo while she was with me that day, the day that she died. Okay, well, look at her nose. Look at her nose ring. It's a solid post nose ring. Well, according to the autopsy, hold on, let me pull it up. According to the autopsy, when her body was found, she had a gray, right here in this first red box that you see on the screen, she had a gray metal loop present within her left nostril. Clear stone stud earrings present with the bilateral ears. So she did not have the stud nose ring in her ear. Look at the coat that she's wearing. That is not the coat or the jacket that she was wearing when she was found. Then, when you refer to the autopsy report, on page 46 of the autopsy report, it says, signs of neck compression, ligature strangulation to the neck, particular within bilateral eyes, ligature further mark on left lateral side of the neck. It goes into all of these things. And then it says, number 3, IV tracts within bilateral antecubicular fossa, postmortem toxicology, which is where the pathologist stated in open court she had enough fentanyl in her system to kill a horse. She also had track marks on her arm. Now, let me remind you, this photograph right here, which is what Garrett Kurtz testified to at Ashley's trial, was taken on March 28th, the day that he killed her. But on March 14th, when she was arrested, with Garrett Kurtz and Ray Hanish's vehicle, this is what she looked like.
Yeah.
This
So
this is not taken within 2 weeks apart. This was never brought to the forefront. This was never questioned. This was a lie. This photograph that was presented to the jury for 5 days on a podium, blown up, that Garrett Kurtz testified was the photograph that was taken of her in her white hat, was not true.
yeah. So the post-conviction attorney was in a bind because this is, one of the things post-conviction attorneys deal with all the time is waiver. Things weren't objected to. They weren't objected to properly. The trappings of the court. And so what should have happened is Ashley's defense attorney should have said, this is a surprise and I'm requesting a 1-day continuance. The evidence that, which the state used, Amy, I know you would get to it eventually, is that they argued very strongly the theme of the closing argument was trophies. Ashley, her trophies were getting Garrett back from Nicole. The hat was a trophy, and I can't remember what else, but trophies.
The
That
trophy
was her
was
closing argument. But
the trophy was
they
that
should
he
have,
supposedly took the hat.
yeah, so it's waived if you need, and it was a surprise. That was never, ever mentioned in any prior statement. It's not in any of the discovery. It, totally sprung on them. Now, the state may have said, we didn't even know he was going to say that. But you've got to ask for the continuance based on surprise to get time to confront that evidence, unless you already
Yeah,
have
I mean,
it.
let's go back to let's
Go ahead,
let's go to
Michael.
Delphi for a minute. Let's go to Delphi for a minute. So Dr. Core gets up there and for the first time in 7 years says box cutter after saying it was 2 blades, one straight edge, one serrated. Yeah. Yeah, you absolutely have to ask them. They hadn't gotten a pathologist because they thought they had the opinion they wanted. And then when Core comes up and says box cutter, and yeah, so they come up and argue the trophies and the hat and everything. And I do want to say something about the picture, and I have the same problem with Delphi, and that is presumably Kurtz took that picture, or that picture was taken on a phone or on some digital device, a digital camera, whatever. And, there's a best evidence rule here, folks. And what they put in was the printout of the actual digital image, the digital file. I'd have been objecting up and down to having that photograph put in. The printout, if they want to put the original in, and they can print out, they want to do a printout, but yes, you mentioned the metadata, Amy, and
Exactly.
absolutely, you'd want to see that.
And that was never requested. It was never argued, and that photograph was blown up and put on a pedestal and sat in front of the jury for the entire week. Blown up.
I never would have allowed it to sit in front of the
And that-
jury
and-
for a week.
Exactly. And that was never
They need
argued.
to take that down, Your Honor.
It was never argued to take it down. It sat there for a week. And then when Garrett Kurtz took the
Is that on the
stand,
record? Is that can you tell that from the record?
I'd have to go back and look. But I would have to go back and look. I have all of the trial transcripts. But the
It's not
photograph,
in the record, I don't think. And Amy, did you got that from family members, credible family members that attended the entire trial, right? Is where I
correct?
remember.
Yes,
I don't think
yes.
it's in the record.
Well, and it's not in the record because the public defender never argued its presence, but it sat there for the entire week. And then when Garrett took the stand, I think there was a foundational argument raised by the public defender, which was overruled, and the photo was allowed to sit there. And then when Garrett took the stand, he said, "Oh yeah, after 2.5 years in interviews where he never brings up this photograph or Nicole wearing this white hat, all of a sudden." What happened was that Garrett's defense team allowed him to watch Ashley Garth's interrogation video. And at some point, someone raised the argument, oh, whose white hat is that she's wearing in her interrogation? Then it became Nicole's white hat. But we've proven, we have photographs of Ashley in that same white hat prior to Nicole's death. But the extent of the argument in post-conviction wasn't for my taste as extensive as it could have been. Because when you look at the autopsy report and you look at the photograph, if that photograph was taken that same day, she wouldn't have been wearing a stud earring, but found with a hoop earring. She would have been found wearing different clothes. Her face, as slender and clean as it was in that photograph, doesn't match the autopsy report where she has heroin acne scars all over her face that are consistent with her March 14th arrest in Ray Hanish's car, where her face is completely broke out. It's the photograph that the court and the jury was presented was a photograph that came from another time frame.
Yeah, so all of those things that leave you dissatisfied about that in the post-convictions stem from the unusual position that post-conviction relief attorneys are always in, that it's largely waived because there was no objection either to foundation, and then if that was overruled, to not requesting a continuance based on surprise, which in Texas we have to write out by hand right there in court and submit it, or it's waived. The rule requires it to be in writing. But anyway, yeah, it's waived, and so he had to pigeonhole it under a different category. And Michael just alluded earlier about that piece of evidence, that maybe he would have done it a different way to put the Court of Appeals into a strategic, believes the term he used, and again, chess, not checkers. But Michael, what's the law on something Amy mentioned earlier? What's the law in Indiana about the state being able to read a certificate of analysis, for example, a breath test result? Are they able to get that into evidence just by reading it or introducing it, or does Indiana law require them to bring in the person at the lab who analyzed it?
Well, you got to bring in the person, if the defense insists, you got to bring the person in the lab who did the analysis. But I mean, breath tests.
Yeah. Okay.
And there's a whole thing about introducing, the certification of the machine did it.
Right.
That but that's because drunk driving things are so common. Yeah, I don't know what the deal is with DNA reports. I really haven't had any DNA cases. I mean, I've kind of got one now, the 25-year-old conviction, but one thing that has to be done is whatever is available has to be gotten to uh, the DNA expert, because just to take the example of this 25-year-old case, I mean, DNA analysis was already done back in about 2017, but a DNA expert has already identified um, two minor profiles that were missed the first time around. And yeah, I mean, there's a lot can be done with DNA, and I don't understand DNA nearly well enough. I kind of move words around on a page based on
Well,
new investigation.
so the way that I understand it, and this is the way that, and I mean, Travis, I think that you can concur that Dr. Silkman is very well-rounded in the DNA expertise of things. The way that I understand it, based on the way that Dr. Silkman has explained it to me, and to put it in layman's language comparable to something that I think that most of the people in the chat can understand, it's a comparison to, say, the Cecil and Bunner report of the phone data in Delphi. They cherry pick what they want you to know, and they put it in their reports. The phone data that fits their narrative, they're going to leave out all of the extra things that may lead you to believe that there's other things going on. So in this case particular, in Ashley's case, we have a DNA report, which is not necessarily a PCR report. A PCR report is going to show you all of the exact levels of alleles of DNA points that were found on each item. But instead of providing the court and testifying accordance to the PCR report, they provided an analysis. The analysis is what they want us to know. And that is an overall view of what areas of items that certain people's DNA and at what ratio the DNA was found. But they don't explain, because they're not made to, because again, the defense did not demand an explanation for anything other than their testimony. They read off of the analysis report. And in each inference that Ashley's DNA was registered, it was also registered as a mixture. And they didn't explain, they didn't provide any ulterior explanation as to who these other unidentified mixtures belong to. It was just, oh, well, Ashley's DNA was present on the scarf, and it was present on the cardboard, not the actual tape, but the inside of the cardboard roll. Well, we have proof that Ashley had used the tape roll that morning to pull off a piece of tape to tape in the phone battery to the back of the phone. That is the phone that you see her hand over in her interrogation video. It's the same phone that you see entered as an exhibit with the black tape on it still. That argument, that explanation is never raised.
Yeah, so
There's
an
so many.
excellent video you have with Dr. Silkman about that. And the thing with a well-qualified DNA expert in Indiana to look at everything, get all of the raw data, and see if there's anything that you can do with it. But this case, it was a little bit different in that Garrett blurted out from the stand, her DNA and Cross, her DNA, her DNA is on the electrical cord. Look at that report. It's in the report. Her DNA is on the cord. And
It's
that
not.
wasn't confronted at all. And so, again, it goes back to even getting a consultant to prepare you for cross and getting them to acknowledge, because the report did say what were the mixtures where there may have been Ashley's DNA profile. The probability was the lowest end of the scale as compared to Garrett's mixture was the highest probability a mixture can have. So when it's a mixture, it's all probability. It's either highly likely, it's Garrett Kurtz versus an unknown person. It's really weird language. And you really need to either have a consultant explain exactly what that terminology means, or you need to have a testifying expert to rebut if they went over. The person for the state who testified didn't overstate anything. They just weren't asked, well, what does this mean? It's the lowest probability. I can't remember. It's like unlikely, likely, and very likely, I think, are the three that the Indiana lab uses, which is what most labs do. But she was at the ultra lowest, but it was Kurt. And there wasn't even an objection to that. Non-responsive, motion to strike. It just sat there. And then you take that with Ashley's second interview, and he asks her, that detective, okay, so there's no possible way your DNA can't be on any of this. Nope. Okay, last chance. And, so, yeah, that's,
So there
go
was
ahead.
testimony. There was testimony her DNA was on the cord when it wasn't.
I can't
Yes.
remember. Cherie, do you remember where the mixtures were found? I know it was on the scarf. I know it was on duct tape. I thought there was 3 mixtures on the cord, and Garrett was highly
No.
likely to be 2 of them, and that it just said Ashley and others could not be excluded from that 3rd one on the cord. But I don't think there was anything in the report,
No.
even that there was a weak link.
Garrett made the comment. It wasn't elicited testimony. First of all, Garrett was a loose cannon on the stand. He answered what he wanted to answer, and what he didn't want to answer, he didn't answer. And he flat out made it clear, I'm not going to talk about this. I'm not going to talk about that. The judge didn't intervene. The judge didn't make him answer. He made the comment during the trial that Ashley's DNA was on the cord. The prosecutor at the evidentiary hearing in open court made the statement that Ashley's DNA was on the cord. John Pinot, for whatever reason, apparently didn't know the answer or have a response because it was stated in open court and he didn't respond. There is no DNA of anyone's on the cord. All of the testing on the cord was inconclusive. No one's DNA is on the cord.
Oh, it's DNA on the cord, but inconclusive, right?
They never identified anybody's DNA on the cord. The testing on the cord came back inconclusive.
Did John clear that up in post-hearing briefs? I know both sides submitted.
No.
Is that
No,
mentioned anywhere in the appellate opinion? Doesn't sound like it.
No. It was never addressed. And when I raised the argument to him, okay, like, why are you not addressing this? When the prosecutor said this at the hearing in open court, he said, I'm not a fan of arguing DNA. I've gone down that road and I've not been successful. That was his response to me.
But I think it came out okay in the post-conviction after the hearing. Both sides presented briefs and they were discussing the 9 factors you mentioned earlier. And it was never alluded to again. So I'm guessing the judge took it as, they said the cord, they meant the scarf. And even the scarf and the tape roll were weak. There's a slight possibility it might be her. But again, the overall, where you have to get a new trial on this is either the state withheld something that would have assisted defense counsel in impeaching Garrett, or that defense counsel was ineffective, and then
Well, the ineffective assistance of counsel claim, in my opinion, should have been much more grandiose than what it was. It wasn't just that. The only argument raised at the evidentiary hearing in regards to ineffective assistance of counsel was the fact that when Garth was found guilty, Lori James was allowed to proceed with filing her direct appeal. And within the direct appeal, she relied on the clerk of courts to submit Garrett's letter in its entirety. And that didn't happen. So the direct appeal ruling that came back denied. They didn't have access to reading the full letter. That was the only argument raised as far as ineffective assistance of counsel. Oh, wait a minute. And the fact that the murder of Ray Hainish, and this wasn't clear to me how this was ineffective assistance of counsel, because it was a ruling by the judge that the information could not be allowed in. It was literally the fact that Lori James attempted to get the information in about Ray Hainish's murder, and because no one had been charged, the judge was not having it. So all of that information came in during the evidentiary hearing. And also, the January 21st attack on Ashley, where Garrett broke in her house, strangled her, hog-tied her, duct taped her up, and beat her, that none of that was allowed in the first trial. That came in during the evidentiary hearing. That was the first thing that came in during the evidentiary hearing. And Judge Mueller, who overseen Ashley's original trial, when that was brought in, he said, his exact words were, in front of everybody in the courtroom, was, wait, Ashley Garth was a victim of Garth's. And Pinot said, yes, she was his first victim. All of the evidence was presented, and it only took him 1 week to deny the appeal for the post-conviction relief. So outside of that, there are a magnitude of issues that should have been raised by John Pinot on ineffective assistance of counsel. One being Mikey Hiddle.
So John, so what you mentioned about the appeal was ineffective assistance of appellate counsel, but John did raise the ineffective assistance for not attacking the white hat. And then the Court of Appeals said, no, she really couldn't have known about that. And that's why I was saying, at least with hindsight, I'd have backed up the claim with newly discovered. The white hat stuff is newly discovered evidence. So the Court of Appeals couldn't say, well, on the one hand, she couldn't have known about it. On the other hand, it's not newly discovered.
Well, he raised that during the initial post-conviction relief filing, which was then brought out.
That's in his brief.
Yeah, which was then brought out at the evidentiary hearing. But he had information that could have backed that up tremendously. One being the photograph of Nicole itself, putting the two images side by side, that the two hats don't even match. Number 3, the fact that the nose ring that Nicole is shown being wearing in that photograph that they're claiming is the white hat she was wearing when she died is not the same day that she was killed. 2 different nose rings. There was a lot of information that he could have used to support that argument that these weren't the same hats, and he just didn't utilize that information. Then you have, again, what Nicole looked like on the 14th of March when she was arrested versus what they wanted you to believe that she looked like 16 days later. It's not the same. This is what she looked like when she was found. These markings on her skin were absolutely identified in her autopsy report. But nobody took the time to go into that much detail about the case. So we're left with, Ashley is relying on a public defender, not just in trial, but in PCR, to defend her, who don't really seem to be all that involved in learning about the case and having the ground arguments to really fight to get her home. She's just stuck because the law says her attorneys didn't do the right job. Cherie?
Yes. I just sent to you and Travis, and I know you have it, Amy, and he probably does too somewhere, but the exhibits set, and on page 70 to 81 is where the DNA analysis that was presented at trial with no explanation is.
Mm-hmm.
So I just thought, if they wanted to see what they said about the court exactly, it should be in there.
So let me see. What I feel was left off the table in the post-conviction relief filings is these items here. And I'm just going to, this is my opinion. I'm not an attorney. Michael can address these issues. He can tell me how out of bounds I am or not. But first of all, some of these things to me are high on the ladder of importance when it comes to what was left off the table that could have been filed for Ashley in her post-conviction relief. One is a complete absence of attorney-client consultation. Trial counsel never sat down with Ashley Garth to review evidence, handed discovery to Ashley, and told her to review it herself. Collected discovery back on the first day of trial, failed to prepare Ashley for testimony or defense strategy. Failure to investigate and present extreme domestic violence evidence, suppressed home invasion and captivity narrative. That was never presented at Ashley's trial. Suppressed home invasion, captivity narrative, evidence never presented to the jury shows Garth'S broke into Ashley's home, laid in wait for her to return, hog-tied her with duct tape, beat and strangled her repeatedly into unconsciousness. That is in a police report that never made its way into the trial. A 32-page White County Hospital record from March 25th documents injuries consistent with restraint, strangulation, and severe trauma. That is 2.5 days before Nicole Bowen was murdered. It reveals Ashley's actions were the result of coercion and fear and not criminal intent. Strangulation history establishes escalation in homicidal risk. The record includes, on January 21st, strangulation arrest, 2 violations of a protective restraining order, repeated strangulations rendering Ashley unconscious. Strangulation is recognized as predicator of future homicide, which indeed, that's what happened. 14 days later, he strangled a man. 16 days after that, he strangled a woman. Properly contextualizes culpability and identifies the true violent actor. Third-party guilt evidence was never presented fully or fairly. Multiple admissions and confessions. Garth'S told Mikey Hiddle he intended to kill Nicole Bowen. He admitted his motive, retaliation for her snitching. Was captured driving Nicole's car. Made recorded admissions to Hiddle, monitored by law enforcement. Authored a written confession letter. Mikey Hiddle assisted law enforcement in capturing Kurtz and providing intoxicated and recorded admissions. Benefits to the court: it ensures conviction aligns with evidence of actual guilt rather than narrative convenience. Evidence of conspiracy and obstruction was never disclosed. Terry Smothers, who was another witness that was a friend of Talitha Beckley. He destroyed electronic devices. He communicated with Garth'S and Jason Palladino on the day in question, along with Talitha Beckley, and actively concealed evidence. He was never talked to, nor was his name ever brought out in public before Ashley was convicted. His information came out after Ashley's trial, which would be new evidence. This evidence supports conspiracy and obstruction, not Ashley's guilt. Benefit to the court, allows meaningful scrutiny of investigative integrity. Forensic evidence was misrepresented to the jury. Tape on the phone. The evidence supports secondary DNA transfer caused by Ashley handling the tape hours earlier, not participation. Cut extension cord. Not broken, not stretched beyond means to where it snapped, but a cut extension cord was found around Nicole's neck. Evidence shows purposeful cutting, not accidental damage, undermining the state's theory. Prevents convictions based on scientifically unsupported assumptions. Credibility of state witnesses was never properly challenged. Talitha Beckley authored a letter redirecting blame toward Ashley, was romantically involved with Garth's, had motive and bias to provide and protect him. This was never disclosed or argued to the jury. It preserves the integrity of witness credibility determinations. Cumulative error renders the verdict unreliable. Individually and collectively, ineffective assistance of counsel, suppressed domestic violence evidence, confessions by an alternate suspect, destroyed evidence, and misrepresented forensic proof. Undermine the confidence in the outcome. The benefit to the court protects the justice system from ratifying a verdict reached through omissions and distortion. This is not repetitive litigation. It is the first opportunity the court to consider unraised constitutional violations, new corroborated evidence, third-party guilt proof, and actual innocence claims. Benefit to the court balances finality with fairness, the core purpose of successive review. Summary of why successive PCR should be allowed. A successive filing is justified because critical claims were never litigated. Evidence established coercion and control. Confessions and recordings implicate another actor. Forensic evidence was misleading. Counsel's failure deprived Ashley of a fair trial, and denial of review risks a miscarriage of justice. And I'm done.
That's a really good analysis and very pointed. How did you put that together?
Yes, and I even left like 2 pages off, but sticking to just the provable facts, not, I have a lot of emotional attachment to this case. So
we do know that, and for good reason.
So there are some things that I can presume to be true, and there are things that I can feel relate from one rationale to another, but I can't prove it, even though it makes sense. I'm looking at what we can prove, which is what matters. And those topics were the things that I felt were left off the table in the initial post-conviction relief claim. That, and I'm not putting down John Pinto by any means, because the information that he did provide did lead us to an evidentiary hearing, and it's led us to obtaining a positive ruling on 8 of the 9 prongs that we have. We just have to get over this last hurdle. But it's so.
I think it's only 7. There's nothing about whether the newly discovered evidence would produce a different result. It just stops at impeachment.
No, well, according to the appellate court, she met 8 of the 9 prongs. The 9th prong being the merely impeaching about the letter.
No, the ninth is that would likely produce a different result at a retrial.
Okay. But
so they
she did.
stop at 8.
Okay. Yeah, because they didn't address the first 8. They went straight to the 9th. I mean, can you explain that?
Yeah. Well, yeah, you don't have to discuss the others if you can blow something out on one.
Right.
So we really don't have there's no court. It's not like we've taken care of 8 of 9 and just have to get this 9th. That they blew it out on 8. So, you know, who knows what they'd say about 9, even if, or who knows what the Supreme Court would say about 9, even if they say what the Court of Appeals did with 8 was wrong.
So what is your, well, I don't want to ask you that about your opinion on the last filing in her case.
Well, no, I mean, John answered, you know, John did a great job answering the state's transfer response, and that's fine. I'm just trying to sort of disabuse people of the illusion that somehow all the other 8 things have been gotten past. We just have to get past this impeachment thing. I just don't think that's true.
So what else do we have to get past?
So there was no discussion of anything else. So the other 8. And I would say the hardest one to get past is whether it would produce a different result at a trial. Would getting this information about Kurtzen will likely produce a different result? And again, what I said earlier is these things are all hypothetical. So a court has to sit there. I mean, let's say the Supreme Court says, okay, this wasn't merely impeaching. Then they have to say, well, would it likely produce a different result at trial? Which, you know, that's kind of a weird hypothetical judgment to make, and I actually don't. I can do the reasonable probability thing pretty easily. I mean, that's a little easier to weigh, but you know, likely to produce a different result, God, that's hard to figure out.
So the way that I read it is that she met all 8 prongs. And they specifically refer to that they're not going to address those because they're in agreement with the appellate court. They were going to address the 9th one, which was the merely impeaching on the ineffective assistance of counsel of the letter. So based on your dealings with the Supreme Court, what do you feel? Because I feel like John Pinot's brief, his last filing was literally, and this is something that we talked about earlier, about applying the law to the rule and how it was applied. And we don't have to get into the details of that, but is that a strategy that is favorable with the Supreme Court, to where the argument that John raised, they're going to look at it and go, yes, we agree. The law was applied wrong, or are there loopholes and what have you? And
so the thing that's immediately interesting about that might be interesting to the Supreme Court about this case is where so the post-conviction trial court findings of fact kind of conflict with the conclusions of law it makes. I mean, they both can't be right.
Okay.
State in its transfer response tries to dance around that. And that's really hard to dance around. So I don't know what the Supreme Court would do about it. That's the interesting sort of abstract legal question that might interest somebody on the Supreme Court.
So so let me ask you this. Where does that leave a client who is relying solely on the expertise of the lawyer that represents them to have the knowledge or the forethought or the ability to articulate what needs to be articulated in writing based on the law as a defense when they are legitimately innocent, but the crossovers and the legalities of the restraints of the courts are limiting the truth coming out, just because from the onset, at the preliminary basis of the original public defender that was assigned, who represented the client, that the client truly trusted to have her best interest at heart, even though now we realize that that public defender was bare bones, raw dog, not equipped to represent a murder case, and left all kinds of things off the table. How do we fight back to get back to ground zero to represent this person who is factually innocent and get all of the cards on the table? How do we do that?
Yeah, it's a hard question. I mean, we'll see what happens on transfer, and then there's your list and to be massaged into a request for a successive post-conviction petition. She's got a year to file a habeas petition. Might want to get what DNA we can at least the DNA results, to the extent they exist, to an actual expert. That'll probably cost some money.
To start with, we need the PCR report, not the analysis, not the overview that the state wanted to present. We need the actual PCR report, just like we need the actual PCR report in the Delphi case. They can tell us what they want us to know. Well, there was not enough DNA to create a whole DNA profile, but they want us to also believe that the Patty's washing machine was capable of transferring DNA into clothing that only resulted in landing on the private parts of both girls, but only transferring male DNA, because we don't have unidentified female DNA anywhere else. And they wanted us to believe that, well, because the girls lived in a house with a male, well, Abby didn't live there. So for the DNA that they proclaimed was available, that was unidentified, that was male, on all of the female private parts of the girls was only male, and more than likely was transferred by the washing machine. So no, you need the full test results, the PCR, which shows you every single level of DNA collected and how many alleles and how many stats they have on each item. We need to start there. Then if a DNA expert in Ashley's case needs to be brought in, that could be requested. But the analysis is only an overview of what the state wanted to present in court, and it was never challenged. So, and the analysis alone had Ashley's DNA at very minimal. And the two places where her DNA was a mixture. Then you have the victim itself, which was Nicole Bowen, where they took saliva swabs, blood DNA, and anal and vaginal swabs, but then state later in the autopsy that there was no DNA standard or profile created for the victim. So it's
that I find that's I mean, have they even exclude? So if there was no profile for the victim, they can't even. I mean, if there are mixtures, I mean, they can't even exclude. If there's no profile for her, they can't even exclude her.
right.
That's bizarre.
There's no DNA there. Yeah, there's no profile for her.
I mean, presumably. So explain this to me. If she was strangled with this cord, how is it that her DNA is not all over the cord?
Exactly. What transpired when they walked in the door, Ashley was not stranded there for over 12 hours. She didn't know if he was coming back to get her. She had called her grandmother, and her grandmother will testify to this, that she was able to get a call out. Now, where she was left at Jasmine Parker's trailer, Jasmine Parker was stealing Wi-Fi from the neighbor. So Jasmine wasn't allowing Ashley to utilize Jasmine. Jasmine wasn't letting her use her cell phone. The phone that Ashley had in her possession had no connection to anything. This was the phone that Ashley put the tape on the battery to keep in the phone, which was collected at her interview, which was then admitted as an exhibit with the tape on it. Ashley reached out to her grandmother saying, I'm not sure where I am. Garrett's taken me out here. I'm somewhere in Kitland. Can you come and get me? Her grandmother refused to drive out and get her. Her grandmother now obviously regrets that. She was like, I didn't know what the hell was going on. And I feel awful because I should have went and got her, and I didn't. When Garrett showed back up close to midnight and this fight broke out, I mean, Ashley comes out of the bedroom. Garrett, Talitha, and Nicole are standing in the living room. Immediately, Ashley knew she was in trouble because she knew that Talitha didn't like her. Talitha was a Palladino, whatever you want to call it, crony. And she knew that Nicole, for weeks, had been threatening her on Facebook because Nicole was Garrett's, at the time, girlfriend, aka fiance. Garrett had posted a engagement ring on his Facebook page in February. So Nicole was attempting to, put that in Ashley's face and say, come on out and fight me, blah, blah, blah. Nicole attacks Ashley. And Ashley says that they both grabbed, that when Nicole attacked her, they both went for each other's hair. Ashley said she didn't even get to fight her off. She was just holding on to her scalp. Nicole was holding on to her scalp, and Nicole started punching her. And then Garrett intervened and swooped her up by the neck, which explains why Ashley's DNA was under Nicole's fingernails. But the cord, Garrett choked her to the point that caused bruising on his arms, both arms. And I will pull that up here because I have photographs of him. Five days after the murder, they took photographs of Garrett's arms. And Both of his arms show dark yellow bruising from where he wrapped Nicole up and strangled her. I believe that Nicole was already dead when she hit the floor. He choked her that hard because his arms show that much bruising.
You don't get bruising on your arms from like wrapping somebody up. I mean, you get bruising from being hit.
Hold on.
You don't get bruising from exertion.
Well, I'll let you decide.
Well, no, I mean, it's sign. What it's actually a sign of is fight of some sort.
Okay, hold on. I want to take these down because I don't want to put on any.
I mean, when was the last time when was the last time you lifted something really heavy and ended up with bruises on your arms? I mean, seriously.
Well, his forearm and the crook of his elbow were black and blue.
I understand. I'm just saying that you don't get black and blue from exertion.
Well, then what would have caused that? When Ashley explained in her interrogation video that he wrapped her up with his left arm, the arm with the tattoos on it, and he squeezed her so tight that she collapsed. What would have caused that bruising on his arm?
Being hit with something or hitting it against something. I mean, it's
Well,
it's not exertion. I mean, ask somebody in the chat. I mean, I'm not a doctor, but I've never in my life. I mean, no matter how much I exert myself, I don't end up with bruises on my legs or arms because I've exerted myself.
well, because I have it handy. Here's the phone that was collected from Ashley during her interrogation video with the black tape on it. The same tape that she claimed that the morning before the murder, she put on the phone to keep the battery in.
And do we actually know that tape came from the same roll?
They never said, because a minimal amount of her DNA was on the inside of the cardboard. But they never explained. Hold on, I'm looking for. Okay, so this is the inside of the trailer. This counter right here. So to the far back right, where the door, where you see a light illuminating, that's the master bedroom. That is where Ashley was with Jasmine. Jasmine was doing laundry. And this area right here, immediately outside of that door. If you walk out that door, like you're going to come out here into the kitchen, there's a doorway right there on the left. That is the doorway from the attachment to the outside. That's the doorway that they came in. And Garrett and Nicole and Talitha came out here around where the bar area is. And that's when Ashley came out of the bedroom, hearing them come in, and the fight broke out right there where the wood flooring is. Stop it. I think we lost Michael. This is the outside of the trailer. That was the original plan. Oh. Sorry, not showing those. I'm looking for Garrett's arm. Okay, Michael's back. Stop.
Yeah, I'm gonna have to go in a minute or two. I'm just staggered that if she was strangled, if Nicole was supposedly strangled with this cord, and what world is her DNA not on that cord?
Well, I think that I think that he at least choked her out unconscious with his arm. And then he went and got the cord, like he claimed in his second interrogation video. He went and got the extension cord from behind the TV, and it was plugged into the surround sound, like he tells Detective Rowe in his second interrogation video. He comes back, he ties the cord around her neck, then he ties a scarf around her neck. But in between that time, he ran to the back bedroom where Ashley had ran to and was screaming at her because she wasn't helping him, and he hit her. Even Talitha Beckley, in her interrogation video, describes that incident, that he came to the back bedroom where Ashley was and hit her. She was crying. So I don't know if she had sweat and tears on her face when he hit her, and he went back out and he grabbed this scarf off the lampshade and tied it around Nicole's neck. But the DNA testing on the cord was inconclusive. Nobody's DNA was on that cord.
But wasn't Kurtz's testimony that she handed him the cord?
Yeah. But
so what I'm saying is, and what I'm saying is, if the cord was in fact not, so it's the cord, not the scarf, right? I mean, the state's argument is not that she gave him the scarf to strangle her, but she gave him the cord to strangle her. Am I understanding this correctly?
Yes.
Okay. So what I'm saying, right. And so what I'm saying is, maybe you need an expert opinion. I don't think you need an expert, but if her DNA was not on the cord, then the cord was not used to strangle her.
Welcome to my life. Welcome to our world. That's the point. Because he stated in his interrogation that he went and got the cord from behind the television, and then he describes what it was plugged into, which was the surround sound. Then at trial, he claimed that Ashley handed him the cord, and then he tied the cord, and then Ashley pulled on it so tight it broke. But when you look at the autopsy report, the pathologist claims that the cord around Nicole's neck appeared to have been cut.
But is there the cause of death was ligature strangulation. I mean, do we know? Is there some opinion there that it was the cord that strangled her?
She had a cord. He wrapped her up with his arms, with his left arm, his left forearm,
yeah.
and choked her to the ground. She collapsed. Then he went and got the extension cord. So I don't know how far gone she was, but she was unconscious. Then there was something like an extension cord tied around her neck. He tied that around her neck. Then he tied a scarf around her neck. In between the cord and the scarf, he went back to the bedroom screaming at Ashley because she wasn't helping like he had demanded her to, and he hit her in front of Jasmine and Talitha. They both say that in their interrogation videos, that he came back there furious and hit her. Then he went back out and did what he did. Ashley's DNA was under Nicole's fingernails. And there was a very small amount of her DNA on the scarf and on the cardboard roll that was found with the body. There was no DNA on any of Nicole's clothes, any of the duct tape that was used to hog tie Nicole. There was no DNA on the bag that was put over Nicole's head. There was no DNA on the blanket that Nicole was wrapped in. There was no DNA that the tape that was used to tie up the blanket that Nicole was wrapped in. That was all Garth's DNA.
I'm just trying to make a smallish point, but maybe an important one, that if so the aiding and abetting charge is supported by Nicole. I'm just saying, suppose it is true that she handed him the extension cord. There, without Nicole's DNA on the extension cord, there is no evidence that was used to strangle her.
Right. There was no DNA on the cord at all.
Right. So I'm just saying that there's an absolute lack of evidence on an element.
Mm-hmm. Despite the fact that in his second interrogation, he describes where he got the cord from, and his DNA is not even on the cord.
I understand. I'm just saying. Yes, I mean, so it didn't. I mean, I'm curious about, what sort of marks there were on Nicole's neck. I mean, hard to kind of.
There was substantial. There was substantial. I'll send you. I have 136 pages of exhibits. I'll send you. And they have all of the autopsy reports that were, or images that were presented at trial. I have all of them. I can send them to you.
The other, I mean, I hate conspiracies and things if you can't prove them. But, if in fact there are marks that would be consistent with Nicole having been strangled by this extension cord, then there's something really wrong with the DNA reports.
Mm-hmm. And I'm going to tell you right now that there are very clear ligature marks around her neck. Once the items are removed, you can see the ligature marks around her neck.
I mean, theoretically, the scarves. She wasn't. The scarf would have been just to cover up the cord, right?
That's what it appears to me. It almost feels like an overdoing of what he was trying to accomplish. But the fact that at court he testified that Ashley pulled on the cord, it's almost like he's somebody that tells a story that if your eyes aren't bulging out of your head on the onset, the story gets more elaborate. So he just kept going, and he was allowed to keep going. And he was like, well, she pulled on the cord, and then she pulled on it so hard that it broke. Well, the amount of physical force or strength that it would require from a female to pull so hard on an extension cord that it would snap, first of all, there would be some indication of that on the cord, that the cord was overstretched where it absolutely stretched and broke. But the coroner stated that the extension cord appeared to be cut, like it was tied around her neck and she was probably unconscious and he tied it around her neck so tight and tied it in a knot. Then he cut it so the excess length of the extension cord wasn't hanging. Then he tied the scarf. We just don't know.
Was the excess length found?
No, not that I'm aware of.
That's pretty weird.
And then there's also video captured by a neighbor from across the street that was never admitted into trial, that was turned in to Detective Rowe, who, for whatever reason, didn't feel the need to make it a part of the discovery to send to Ashley's attorney. But I found out about it because I re-listening to Garrett's second interrogation video. Detective Rowe comes in and he's got vanilla envelopes or vanilla folders that he's opening up. And he's showing Garrett these photographs and he's saying, whose car is this? And this was parked outside of Jasmine's trailer. And then he starts going into, well, I watched you back Nicole's car up down the side of the trailer. Now, this is like 3 o'clock in the morning. It's after midnight, well after midnight. And Garrett's stupid enough. He's going, yeah. And he said, well, what kind of lighting were you using? And Garrett says, a headlamp. I had a headlamp on. And apparently this video shows Garrett dragging the body out the back door of the trailer and putting the body in Nicole's trunk in her own car by himself. Now, normal people would think that if this was a conspiracy and Ashley was involved, that Garrett wouldn't be left on his own to dispose of the body, drag her out of the trailer and put her in the trunk of the car and leave with her, and then call his friend, Chris Mathis, to pick him up to help him dispose of the body. But all of that footage was left out. But it exists.
Well, it's all very interesting. I kind of got to get off, and I'm sure we'll pursue that later. I'm still really interested in this court business. But thank you for the opportunity to participate, and see you after the Rose Bowl.
All right. I'll see you later. Thank you, Michael.
Bye.
Bye. All right, guys. We've been on here forever and a day, and I have another episode of Transparency, where we're going to bring out all of the Patrick Westphal insights. So, Cherie, what do you think?
About which?
I don't know about all of it. I just, we didn't read fully the filings because I was advised not to. But if anybody wants to go read them in their entirety, they're on the My Case website.
I thought his reply, Mr. Pennell's reply did a good job of addressing most of the inaccuracies and lies that were in the state's response.
Mm-hmm.
They were saying that like I'm sorry, I'm drawing a blank here. Like the finding of fact by the court didn't support their conclusions, and the state was saying that, well, it doesn't have to, but it does. It doesn't make sense. Go ahead.
My understanding is that, so John Pinno's argument basically implied that the appellate court abandoned the rule of law when they applied their findings of the ninth prong. They didn't acknowledge, they acknowledged that it was merely impeaching, which means it goes to the credibility of the witness. And we're talking about the letter that Garrett wrote to Ashley telling her, I killed Nicole because I didn't want her to hurt you. And then it proceeds to talk about another murder. I know that you're basically, he's saying, I know that you're hearing about another murder that I'm involved in. And did someone else die? Yes. But can I give you the details? No. But in the meantime, I need you to shut the fuck up. You said that you loved me. You said you'd never hurt me, but yet here I am because you went to the police and you snitched on me. So put that in perspective with the type of person that you're dealing with. He's willing to murder to keep someone's mouth shut, AKA Nicole Bowen. Sending Ashley to prison for the rest of her life is a small deed that he's not going to feel any type of retribution for, other than him going into court and testifying is his revenge on her for her speaking up. So there's 9 prongs. Ashley met 8 of them. The last one being the ineffective assistance of counsel when it comes to the letter that wasn't allowed to be read in its entirety at trial. Then it was handed over to the clerk, and the public defender, Ashley's attorney, relied on the clerk to submit that letter in its entirety with the direct appeal to the appellate court. That didn't happen. So the direct appeal, who raised the argument about the letter, went to the direct appeals court, but they didn't have access to the letter. That is part of the ineffective assistance of counsel argument. And then what the letter itself states, which the appellate court claims is merely impeaching. Ashley's claim is, no, it's more than that. It's a confession to the crime, and it's also coercion. Him telling her to shut her mouth, and him also at the time admitting to a secondary murder, which her attorney did attempt to get into her case, but the judge did not allow it because nobody had been charged in Garth's case. And the reason that Ray Hanish's case was important was because there were reasons to believe that Nicole Bowen had information about the Ray Hanish murder. We know that there was a party at Ray's house. We know there were a magnitude of people there. There were over 200 items collected in evidence: Solo cups, beer cans, cigarette butts, DNA, etc. And Ashley was not there, but other people were. And if Nicole was one of them, and that was the night that Ray Hanish was murdered, then if you think that Garrett was capable of murdering Nicole because they got pulled over in Ray's car and she told the police that the drugs in the car belonged to Garrett, what do you think Garrett was capable of doing if he knew there was a risk that she was going to tell on him about a murder? That's the importance of the letter, and it's more than just impeaching. Patty DeGrossi is asking, what did Ashley say happened? Are you talking about that night? Yeah, there was a video, Chris Kruk. There is an absolute video from across the street. Patty, is that what you're asking? What did Ashley say happened that night?
That's the way I take it.
Okay. Oh, hey, Toby. Ashley's daddy is here. What Ashley says happened that night, Ashley was left there, not by choice, at this girl's house that she didn't know. And 12 hours later, Garrett shows up with her, let's just be honest, with Ashley's archenemy, Nicole Bowen. You have to understand that Garrett and Ashley had an on-again, off-again relationship for months until the break-in and the strangulation case. Then there was 2 restraining orders filed. During that time, Garrett was seeing Nicole Bowen. Nicole Bowen and Garrett were staying over at the Palladino's compound. So Nicole, for several weeks, had been attempting to contact Ashley via Facebook by enticing her to come outside so Nicole could show up and fight her. And Ashley avoided that situation. So after being left at the trailer for over 12 hours, when Garrett came in, Ashley heard, according to Ashley, she was in the back bedroom with Jasmine. She heard Garrett's voice. She come probably storming out of the bedroom like, what the fuck? I wanted to go home this morning. You refused to take me home. Yeah, whatever she was thinking, which she was entitled to think. I mean, Ashley is not without right here. She's not without, she's not allowed to not have emotion here. Ashley is a human being who's being abused and manipulated by a man that she has attempted at multiple turns to be incarcerated, that Nick McClellan continuously lets go. So there's a lot going on here where she feels that she's vulnerable because no matter what she does, nothing helps her. So she came out of the bedroom, and not only was Garrett standing there, but Talitha Beckley and Nicole Bowen. And immediately Nicole Bowen sees her and says, what the F is she doing here? Ashley feels the same way, and Nicole charges her. A fight briefly breaks out, and they grab each other's hair. Punches start being thrown, and then Garrett intervenes, and he grabs Nicole by the neck and pulls her back. And from there, he doesn't quit. And that's when Ashley realized, like she told me, when I realized he wasn't letting go and she was hurting, I was like, oh my God. And she took off to the bedroom. That's what Ashley said happened. So, what time is it? It's 4:03.
She added, Patty added that she wanted to know what she said about the cord, Ashley.
Do what now?
She wanted to specifically know what Ashley says about the cord.
No, she said
she didn't touch it.
No, she never went and got the cord. She never went. Yeah, she never touched the cord, and she wasn't sure about the cord even being used. She knew that Garrett, because her view from the bedroom, she could see he was doing stuff, but she didn't know what exactly he was doing. She wasn't fully aware about the cord until after Garrett's interrogation video, when her attorney told her. And she was like, I never touched that cord. But we know, based on Garrett's interrogation video, it's almost like you can watch it in real life playing out, where his mind and his gears are changing. When Detective Rowe is asking him, okay, what did you do next? There was an extension cord, and Garrett was like, yeah. And Detective Rose says, well, how long was it? And Garrett looks over at the door frame and he goes, well, it was about as tall as the door frame. And Detective Rose said, where'd you get it? And he said, behind the TV. And he said, well, behind the TV where? And he says, well, it was plugged into the surround sound. How would he know that?
Right, you guys got the formula that I sent, right?
What?
You got the formula that I sent, right?
The what?
The formula that I sent, you got it, right?
I think so. Ask Mike real quick. Sorry, my daughter is here. She just dropped my grandson off.
It's my understanding that she wasn't, after Garrett took a hold of Nicole and the fight stopped between those two, she went to the bedroom and she wasn't, maybe she could see partially what was going on, but she wasn't out there with him. And don't Jasmine and Talitha support that she was in the bedroom?
Yes, they do. And even Talitha's interrogation video, which Talitha's testimony changed, and it changed from, her interrogation video where she had all of this insight to her testimony of, I don't remember. Talitha claimed that Ashley came in and she was hysterically crying and she acted like, both of them actually, Jasmine and Talitha both acted like Ashley was nerve-wracking. Like she was screaming and crying and we were like, oh my God. And then Garrett came in and hit her, I guess, for not doing what she was told because Garrett was asking for help and she ran away. Garrett chased her in the room, hit her, and then Talitha in her interrogation video states that she jumped up in between them and told Garrett, what have I told you about hitting on her? So as far as I know, Ashley never has ever claimed that she ever touched the extension cord. So I guess now all we can do is wait and see what the Supreme Court decides. And then hopefully we have a pit bull who will file a succession if that's required. Because I have a whole entire list, starting with Mikey Hiddle, Terry Smothers, who destroyed electronics, the letter from Talitha, where they're discussing Garrett Kurtz giving Nicole Bowen a hot shot. All of the things that should have been raised at her trial, which some of it could have been raised at her trial, but some of it wasn't known at the time. So Cherie, are you there?
I am.
Okay. Well, I'm going to let everybody go. What time is it? It's 4:07. I'm going live again at 5:30. Yeah, Travis. Exactly. Travis says she was pretty clear in her interview that she never touched the extension cord, never handed anything. Yes, she was very adamant about that. So I will be, thanks everybody for being here to listen to us rant. I will continue to be a voice for Ashley. I know Cherie will be. She has my heart. I feel for her. I feel for her family, her son, and just so you guys all know that the Northwestern Northwestern wrongfully convicted clinic reached out to us and had expressed interest in picking up her case, which is another reason why I remained quiet about all of the details of the ongoing filings in her PCR now through to the appellate court, to the Supreme Court, was because I didn't want to put that opportunity for her in jeopardy. We are still waiting to hear what their decision is. I don't know if it's going to rely on what the Supreme Court decides. They have been in contact with me numerous times, and they've also contacted John Pinot, Ashley's attorney, about getting involved in her case. Her case has gone through 3 levels of review, and her case has made it to the final level, where it comes down to they take action or they don't. And they only respond to defendants, from my understanding. So they've reached out to me to get information about her case and to make contact with her attorney and to get the details about her post-conviction relief filing on top of the information that they already did have. But they did reach out to John, and Ashley has wrote them to get confirmation on where her case status is with them. So we're waiting to hear back about that. And anybody else who's watching and listening, just remember, this can happen to any of you. Injustice can happen to any one of us. And unless you have a voice or an advocate out there fighting for you, just like we're fighting for Rick Allen is no more important than an Ashley Garth or anyone else. Ashley Garth is what got me involved online with taking the work that I do public, and she will always be in my heart. And I just need everybody who follows Delphi, because you understand the inner workings of the corruption in that state and how things are mishandled. It should be just as important that another case coming out of Delphi that was mishandled, and I'm not saying that there was corruption, I'm saying there was favoritism. There was favoritism to Garrett Kurtz that might not have ultimately resulted in her conviction, but it sure in hell helped hinder a non-guilty verdict, because Nick McClellan providing a favor to Garrett Kurtz's family by letting him off for the domestic violence and the restraining orders hurt Ashley's case tremendously, because it wasn't allowed to be brought up in her trial. So, and there's hundreds of cases out there like this. That doesn't mean that everybody's in prison is innocent. It just means that the ones that are need to be having a spotlight shone on them. Cherie?
I agree. Yeah. Did you ask a question? I didn't hear it if you did.
No, I was just asking for your input.
Oh, 100%. Yeah. There's corruption there, and that's part of what's wrong with Ashley's case and the Delphi case, and probably a lot more others. David Kallenberger. It's infuriating and terrifying.
It is. 48 years. That's a life sentence as far as I'm concerned. I mean, especially to a mother. It's definitely a life sentence. And I won't fight. I won't stop the fight until I get her home. So I just hope that everybody will help boost her up and corral around this case and help us continue the good fight. Okay. All right, guys, I've chewed your ear off enough. I will see you this afternoon. Well, later on at 5:30. We'll be back on with transparency and meringue, and we'll dive back into the insights of Patrick Westphal. Bye, Cherie.
Bye. Bye,
Bye.
everybody.
Bye.